Hello, I'm attorney Dan Marr from the Nashua, New Hampshire law firm of Hamblett Kerrigan. I've been practicing law in New Hampshire for about 37 to 38 years, and about 28 years in the Commonwealth of Massachusetts, litigating in both states. And I'm going to be talking about the fiduciary who's a bully in a situation. I've had plenty of these where I've been in litigation in regards to a person that's been picked by mom and dad as the last child, perhaps, who is, or sometimes could be some institutional trustee or something, but usually not. It's usually somebody that's a family member. And they say, back off, mom picked me, so I get to make all the decisions. And I get to decide when you're going to get paid. I'm going to decide when I'm going to sell the property. And I'm going to decide whatever I want to do because mom picked me. Wrong. You do have rights. You should talk to attorneys about that as a fiduciary. When mom and dad picked them as a fiduciary, whether or not they're a trustee of a trust or in some other capacity there, as they're acting as a fiduciary, they have the beneficiaries, including yourselves, assuming that it's one sibling with the others, or maybe it's with grandkids, or whatever it may be. They have to act in good faith, and they have to act not just for their own self-focused interest. They have to actually particularly look for all the beneficiaries' interests and what the goals are of the trust. So when I've dealt with these cases, one of the first things I want to do is I want to look very carefully at what the trust document says. And usually the settlors or grantors of the trust, being mom and dad in most situations like that, they're giving some indication, instructions as to how they want things to happen. It might be a situation where one child is a spendthrift and they want to make sure that that person takes care of certain debts before they get paid. And if that's the case, then the fiduciary is not breaching their fiduciary duty by following the trust to some parameters. I've had litigation in regards to that where I actually had a case where the trust agreement said that, and the trustee who hated his brother was in a situation where he kept on making sure that the brother was not getting any type of distributions. He kept on investing into growth stock. So there was no income coming in, and therefore no distributions to his brother, for his brother to pay off a debt and then be able to get the distribution, because the brother who was the fiduciary hated the brother that was the beneficiary. Bad idea. Didn't work out well in litigation. We went into litigation on regards to representing the brother who was a spendthrift, frankly, to make sure that the brother who was doing a great job with growth stock, he was investing in it, he was turning it over. His goal was to bypass his brother, and if his brother died before paying off the debts that he was supposed to be paying, it would go to the child. That's a clear example of breaching of your fiduciary duties when you're trying to figure out a way to undermine the beneficiary. And you certainly want to look at the beneficiary issues in a standard fiduciary situation where if it's supposed to be divided to all three siblings and one of them is living in the house and they're the person that's in control of the property and they're dragging their feet, you might want to talk to a lawyer about going into court and judging them along. And the probate judges or the judges dealing with these trust issues do explain to the person, even if they're unrepresented, their fiduciary obligations. They have to act appropriately and move forward in their best interest of the beneficiaries of the trust. So them just wanting to live there, maybe rent-free, and maybe just pay the taxes, and they're benefiting from, they had been the one who was taking care of mom and dad or being in the house for a while, and they're used to being in the house and they don't want to change that. Well, they don't have to leave the next month, but the court's going to look at that if they're dealing with it as you can't prolong this out. If the trust says you're supposed to liquidate the assets within a certain period of time after the death of the last of the parents, the court's going to look at that carefully and nudge the fiduciary along or remove the fiduciary if they're not doing what they're supposed to be doing. So if they're acting in their self-focused interests, selfishly, the court's going to look at that. There is a possibility that if they're harming the beneficiaries by that selfishness, they might be actually having to pay attorney's fees. There's provisions in the New Hampshire Trust Code that allows for the discretion of the court to grant some attorney's fees on anybody's sides in regards to the trust code violation. So there's possibilities there, and there's some downside in that. I've dealt with that for quite a bit of years. The breach of fiduciary duties, both in defending somebody that's accused of breach of fiduciary duties and also going after somebody that we're thinking are breaching the fiduciary duties. And I'm happy to help. I've dealt with that both in New Hampshire and the Commonwealth of Massachusetts. I'm Dan Marr at 603-883-5501, 603-883-5501, and I'm happy to help if the opportunity arises. You can also check out my vlogs by going to our website at nashualaw.com, nashualaw.com, and then check out my bio, and then from there you can get onto the YouTube vlogs that I have that are all identified by weekly topics that I do, and I'm happy to help if the opportunity arises. So I look forward to working with you if the opportunity arises. Thank you.